This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're explaining why choking a friend to death in a wrestling match is not a covered loss, and why coverage from a business insurance policy is limited to acts in the furtherance of the business itself. Jodi Greenlaw, as personal representative of the estate of her late husband Philip J. Greenlaw, appealed from a judgment of the Superior Court granting a motion for summary judgment filed by MMG Insurance Company on MMG's complaint seeking a declaratory judgment it had no duty to indemnify Joseph McNeely, a close friend of Greenlaw, in a separate wrongful death action that the estate filed against McNeely after Greenlaw's death. In MMG Insurance Company versus the estate of Philip J. Greenlaw et al., the Supreme Court of Maine on April 18, 2024, interpreted the policy as it was written. The case started because in 2019, McNeely operated as the sole owner of a landscaping business called Cutter's Edge Lawn Maintenance. MMG issued a business owner's insurance policy providing both property and liability coverage to McNeely. McNeely had discussed with Greenlaw, his close friend, measuring and providing a proposal to hydroseed Greenlaw's backyard. On May 20, 2019, Greenlaw hosted an informal social group of men at his house. The group met year-round on Monday evenings to share their enthusiasm for motorcycles by eating, drinking, telling stories, and taking a ride together if the weather permitted. The group also discussed business-related topics and engaged in frequent business dealings. McNeely attended these meetings when he could. McNeely and Greenlaw went to the backyard where McNeely measured and provided pricing for the project. Greenlaw said he planned to think about the project and would get back to McNeely about it. At around 8 p.m., Jodi returned home, and the men, including McNeely and Greenlaw, were inebriated. After 10 p.m., Jodi asked how the measuring for the hydroseeding went, and either McNeely or Greenlaw told her about the project's progress. Late in the evening, while sitting and gabbing, Greenlaw initiated a wrestling match with McNeely. During the wrestling bout, McNeely put Greenlaw in a chokehold, and Greenlaw lost consciousness and died soon after, despite McNeely's efforts to revive him. The MMG policy itself stated that MMG would pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury to which this insurance applies. The MMG policy defines and insures anyone designated in the declarations as an individual, but only with respect to the conduct of a business of which the named insured is the sole owner. The estate contended that whether Greenlaw's death occurred with respect to the conduct of McNeely's business was a triable issue of fact, and that the court erred by discounting the earlier business dealings and the litany of other facts when summarily finding that the wrestling itself was not business-related. Unambiguous contract language, however, must be interpreted according to its plain meaning in the state of Maine and almost every other state. The Supreme Court concluded that the MMG policy provision was unambiguous. The MMG policy designated McNeely as an individual, and McNeely was thus covered as an insured only with respect to the conduct of a business of which he was the sole owner. The Supreme Court found that the trial court did not err in determining that there was no genuine issue of material fact, and that McNeely's actions while he was wrestling with Greenlaw were not with respect to the conduct of McNeely's landscaping business. Although it is undisputed that earlier in the evening McNeely had measured Greenlaw's backyard and discussed his landscaping business with several individuals, there is no contention that McNeely's actions while wrestling with Greenlaw were to further McNeely's business. In the opinion of the Supreme Court, an ordinary person would not think that the policy's language would cover McNeely's actions while wrestling with Greenlaw. In my opinion, getting drunk with a friend, entering into a wrestling match at the home of the friend, and choking the friend to death could not be part of a landscaping business of the Insured, even though the two discussed business before the drinking and wrestling began. Wrestling and a fatal chokehold have nothing to do with landscaping, and there was no potential for coverage under the commercial policy. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you can also subscribe to the videos published at the same time. They're all free. And if you do watch the videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.